A very good afternoon to one and all. I'm Arjun Philip George. I'm the senior editor at the Quest SLR, and I'm also pursuing my LLM at Central University of Kerala. So, welcoming all of you to the panel discussion on telling feminism through theory, experience, and judgment writing in India, organized by the Quest Sociolegal Review in association with the Center for Human Rights Symbiosis Law School, Hyderabad, and OXFAM India. Through this panel discussion, we aim to give the participants an enriching learning on different aspects of feminism, like that of feminism under the Indian texture. We will be tracing feminist theories through case studies. We will be trying to learn the economics of gender inequality. We'll be trying to learn and study and hear about the feminist judgments in India. We have here with us respected Professor Aakash Singh Rathore, who will be making the opening remarks. And we also have respected panelist, Ms. Flavia Agnes. She will be joining us soon. Ms. Ranu Bhogal, Director, Research and Campaigns, OXFAM India. Professor Jhuma, Associate Professor and Assistant Director, Center for Human Rights, Jindal Law School. Ms. Nabeela Siddiqui, Research Assistant and Teaching Assistant at National Law University, Jabalpur. Uh, so before we begin, I would like to introduce uh, Professor Aakash Singh Rathore and our panelists. Professor Aakash Singh Rathore is a philosopher of international repute. He is author of 8 books, including the Ambedkar's Preamble, A Secret History of the Constitution of India, which was published in the year 2020 by Penguin Books. He's a regular contributor to various newspapers like that of the Indian Express, Times of India, First Post, etc. He's also India's number 3 Ironman triathlete. He's also the editor of a book on Dalit feminist theory. Uh, Ms. Flavia Agnes, she is one of the senior panelists who will be sharing uh, who will be sharing her views today with us. She is a women's rights lawyer. She's a pioneer of women's movement. She has worked consistently on issues of gender and law reforms. She's a co-founder of Matchless, a legal and cultural resource center. Her primary engagement has been to provide quality legal services to women and children. Uh, Professor Jhuma, we have Professor Jhuma here with us. Professor Jhuma is an associate professor at Jindal Global Law School. She is an assistant director of Center for Human Rights at Jindal Global Law School. She writes on feminist legal theories, legal regulations of family, constitutional laws, and feminist legal history. She is also one of the conveners of the Indian Feminist Judgment Project, a collaborative project that brings together activists, academicians, and lawyers to write alternative judgments by using feminist lens. We have here with us Ms. Ranu Bhogal. She is Director, Policy Research and Campaigns uh, at Oxfam India. She has been working in the development sector for almost 30 years. She has extensive experience on issues related to gender, natural resource management, sustainable development, with a special focus on rural development. And finally, we have here with us Ms. Nabeela Siddiqui. She is currently working as a research teaching assistant at DNLU, Jabalpur. Prior to joining DNLU, she was working as a judicial clerk to the National Green Tribunal, Principal Bench, New Delhi. She has been awarded the prestigious President of India, Dr. Shankar Dayal Sharma Gold Medal for her master's degree. She is a member to the International Society of Therapeutic Jurisprudence India chapter. Uh, I welcome all of you to this panel discussion. Moving on to Professor Aakash Singh Rathore, he will be making opening remarks.
Thanks very much, Arjun. It's a pleasure to be with you this afternoon for what I'm sure is going to be an excellent discussion from the panel. I was asked to simply say a few opening remarks. I think the Quest people were just being too kind to me, as they always are, to ask me to do this. These panels will certainly speak for themselves, and and very eloquently. I won't introduce anyone, as Arjun has already done that. There's only one thing about the topic that I think I want to bring up, because I believe I might be the only political philosopher on the panel, and while feminist legal and political philosophy has made an enormous advance over mainstream, largely patriarchal legal and political philosophy as it's taught uh, in most academic law, politics, and philosophy departments around the world today. Um, while legal feminist theory has made these advances, mainstream legal and political philosophy remains quite laggard on a certain point. And so I just wanted to mention that point to bring it into discussion. Um, it's the idea, basically, if we're speaking today, if the panel is speaking today on theory, experience, and case law, the idea of an anomaly that we find in legal and political philosophy between theory and experience. Um, we can take just one very simple example, and that's about gender diversity or representation on the Supreme Court. So, as I'm sure all of you know, uh, out of the 33 judges on the court, only two are women. Um, and I don't think it's an unrelated issue, but I'm not sure whether this is going to be broached here in terms of caste and not only gender inequities in representation, but the two judges who are women are so-called high caste women. So, 2 out of 33 judges seems to represent some sort of a um, inadequacy by any standard of demographic representation. But there's a problem because the theory doesn't support that. As many of you likely know, theories about the impartiality of the judiciary and their function in terms of separation of powers in modern systems of law began emerging in the 17th century and really took full form in the 19th century. And the theorists from the 17th to 19th century were almost without exception men, European men, white European men, who demographically found no uh, gap between their own demographic identities and the positions or roles that they were theorizing about. So, if, for example, a 19th century legal theorist would speak about the independence and impartiality of the judiciary, there would be uh, no discord between his own identity, and generally his own identity and religion and class of the factors, and the people who would be expected to take up those roles within the judiciary and so on. So this is seen very clearly in the legal thinking of Hegel, which turned out to be so important subsequent to Marx and Max Weber, where we get the contemporary ideas about the impartiality of our um, government servants, bureaucracy, and judiciary. What Hegel had uh, described in his jurisprudence or his philosophy of law was was the was the realm of identity conflict as being appropriate to civil society, because civil society consists of diverse demography of conflicting interests. But when it comes time to bureaucracy and administration and judiciary, that conflict ceases to exist. Now, there's an obvious racial and gender reason behind why there's no conflict at that level, because within civil society, you have the sorts of democracies who don't have any function. They can't enjoy power, they can't vote, they don't have any function beyond economic and social functions. So consequently, these social and economic realms of civil society, the realms where there's identity conflict, but the judicial administration and governance, there is no conflict. No gap emerges between demography, those who theorize about the independence of the judiciary, and people who turn out to be judges. In other words, all. Um, now, why does this matter? This matters largely because these theories emerged prior to the cultivation of sociology, for example, as an independent discipline from jurisprudence and philosophy. And what we get, these philosophical claims justify the system that is currently in place in modern India. It claims a certain impartiality of the judiciary, a transcendence of identity markers, whether visible or invisible, caste, gender, religion, and so on, and a representation of this impartiality through certain procedures like the absurd clothing that judges wear, and um, the the uh, the empirical study of whether this impartiality actually gets materialized in case law emerged only after the the uh, uh, the discipline of sociology began aware of and amplified the ways that identities, whether in bureaucracy or government officials and so on, get constantly um, uh, 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 made substantial in administrative decisions or judicial decisions. So the experience that we have post sociology and the empirical understanding that we have is that the judiciary is hardly transcendent of its identity. And the theory that we have demands the judiciary be impartial. This tension between theory and experience as being largely brought into account for why we have situations such as we do, that you have 2 out of 33 judges are women, because there's an immediate response from the theoretical side that can be given, which is that judges are impartial, so they're gender matter. That's the theory of it all. Sociologically, empirically, we know that this is not true. The representative character of a bureaucracy or a judiciary is of decisive influence, not occasional influence or random influence. Studies have shown that it is of decisive influence on the actual content of judgments. So, with this in mind, uh, uh, understand that the conflict between theory and experience can actually be read in case law. If that's true, and I think only legal theorists and political philosophers claim that it's not, the rest of us have seen the evidence. If that's true, then we see very readily why feminist perspective does not need to only be articulated, but it actually needs to be embodied, presented within judiciary, and as well as academia and government and the private sector, and not just in activism and activism. The panel that will be speaking today represents some of these vocations, and I'm sure they're going to speak on what needs doing. All I wanted to point out is in reference to the material importance of a conversation like this, because the theoretical aspect has has a long history of subverting, not supporting, subverting the experiences that we all are aware of. So what we need to do is understand not our experiences from the vantage point of theory, which is what legal theory has been doing for several centuries, but our theory from the vantage point of experience, and in this case, of the experience of feminist activists, legal scholars, academicians, writers. So I'm very happy about this web, and I think we're all going to learn a great deal from the panel today. Thank you.
Thank you, Professor Akash, uh, for his opening remarks. And I would like to quote just one sentence, one statement which Professor Akash uh, just made, that he said that feminist jurisprudence should be embodied in our system. And we have here with us expert panelists who have proved the expertise through their actions, through their experience, and they will be sharing their experience with us today. And so this is something that which we should all do, as Professor Akash Singh rightly pointed out. So I'm not wasting any more time. We will be moving on to our panelists. Our first panelist who will be speaking today is Miss Nabeela Siddiqui, and she will be speaking on retracing Indian feminism. Welcome, Professor. I welcome Nabeela Siddiqui.
Thank you, Philip. Before I speak, I'll just make sure that all of our mics are on mute mode, so to as to facilitate the right progress of voice and both of the video. So, as the topic suggests, and after the wonderful remarks of Professor Aakash, the task given today for me is to retrace the idea of feminism, feminist theory, from the Indian perspective, and how we draw the Indian perspective from the global level by and large. Now, to begin with, the first task that I would give to all of our audience would be to answer two questions and pen them down while the panel discussion goes on. The first question would be how are you a feminist? Second question would be, are you a feminist? So these are the two questions with which I would like to open and would like to proceed in the direction whereby explaining the idea of feminism is all about. So, of course, there are various mechanisms and perspectives to explain feminism. You could have economic model, you could have sociological lens, you could have political decision making as one of the tools of understanding mechanism and feminist theories. But two important key factors, and while dwelling into the two important key factors of feminism, I would like to give a disclaimer. And I start with a disclaimer that you do not need to learn something which you already have or which you already own. And if you have to do the same, that means there is a failed system. And if there is a failed system, we acknowledge there is something that has failed or someone that has failed. And with this disclaimer, I would like to proceed with the fact that the two important ways of defining feminism or progressing the idea of feminist theories would be from the mechanism of going about through a dictionary or a definitive approach. One, or let's say B, the experience based mechanism or experience based approach of defining feminism and feminist theories. So, A by the dictionary or definitive approach, or B by the experience based approach. And this is to my understanding and my understanding through which I've read the vast literature that is available on feminism. Now, if we go by the dictionary or let's say the definitive approach to feminism, the best, the best and the most simplest way feminism has been defined is that it is the advocacy of political, social, and economical equality of the sexes. So this is the most simplest definition that is given to us in the largest sense. And I think just to Google and we get this definition at the first hit. But then there is an idea that subsits behind this definition. That is, that's a belief that men and women are equal in terms of opportunities, in terms of decision making, and of course, in terms of autonomy. So these are the three basic features if we go by the dictionary or the definitive approach, if I were to describe the idea of feminism is. And these three ideas, when coupled up, talk about a pro movement, a positive movement. And of course, whenever there is a movement, there is a theory, there's an entire movement that works in parallel. So this entire movement that works with the idea of feminism is something that I, and to my understanding, would be the lack of understanding of this movement, or let's say the misinformation about this movement, or the loose sense of use of the idea of feminism. Now, moving upon the experience based approach. Now, experience based approach, I think Flavia will be the next speaker, and she'll be giving us highly important points as to this aspect. And when I talk about the aspect of experience based approach, I talk about the idea of institutions such as marriages, such as family and religion. So these institutions are not only the seat of controversy because they have added to the experiences of women, not only in the subconscious mind, but on the face of it, which has called about the idea of discrimination. So moving ahead, in the larger sense, when we go ahead with the idea of defining and also describing about the experience-based approach to feminism, we have two broader notions of feminism. One is the Western-based approach or the notion of feminism, and the other one is a third world country approach or notion. Here in precise, we'll be talking about the Indian experiences. So of course, owing to the geopolitical arena and of course the world order that we are in, there are different countries, and different countries have encountered different problems and have actually developed a different mechanism while dealing any problem which is women centric. And these approaches, in its course of time, if we go by the history or by the literature, are either actionary or reactionary, and in the last sense, sometimes as precautionary. So we've seen that the way people answer to women related issues have been either actionary, reactionary, or precautionary, in both in its legislative intent and as per speaking about the history. Now, the Western notion as to feminism could be, let's say, traced back to the voting rights movement, or let's say the idea of reproductive rights, where we have the case law, the famous case law of Roe versus Wade. And these also have talked about the idea of labor rights. So, for instance, in 1963, that is quite newer to the situation, we have Betty Friedman, who talks about in her book, The Feminine Mystique, the idea, and she talks about the plight of the housewives in America, which to our Indian understanding would have Western notion is considered. But then such ideas have been embroiled upon and described upon and discussed through and through, even in the Western notions. And the Western notion about feminism, talking about the feminism, has responded through its judgments, through its legislations, and through its policy with a more of a actionary based approach. And whereby they've taken actions whenever there is something that is countered upon the famous belief or the famous practice that has been taking place. On the contrary, when we see this whole idea being built up in the third world countries, there happens to be a huge drift, or let's say a difference, a remarkable difference in the whole essence. We see in the developing countries, there are ideas which are developing, such as Black feminism, Islamic feminism, and Dalit feminism by and large, where we talk about vulnerable and subsects. And these are the notions that are growing in the third world countries and also now in the Western notions by and large. So here we'll restrict our observation as to India, because since that's the topic and that's the point where we are discussing about. And in India, we have liberalization, privatization, globalization, that is LPG, as we refer in the largest sense. So in the wave of LPG, we've actually forgotten about the idea of homegrown indigenous literature. And whenever we trace Indian feminism, we usually actually cite a lot of Western scholars, whereas we have Indian homegrown indigenous literature if we were to trace back the idea of feminism. Now, if I were to trace back the idea of feminism in the historical sense, by and large, I would, of course, probably quote Savitra Bai Phule, or let's say Hamida Habibullah, or let's say in the larger sense, Ram Dayal Munda, or let's even go to the extent of quoting Swami Vivekananda. So we have n number of examples who we can actually rely upon while talking about the idea of feminism. But in today's context, that is the contemporary context, the most relevant that appears to me, in my understanding, would be Ambedkar. That is recalling upon the Ambedkar's idea of feminism. Now, when I talk about the Ambedkar's idea of feminism, let me take you back to 1917, where Ambedkar writes an essay titled as Castes in India. And when he writes the essay Castes in India, he creates a link between caste and gender-based oppression. He sees these two units as intrinsically linked and having an influence on each other. For instance, we have a variable A and variable B. So this variable A is directly dependent on the nature and change of variable B. And that's how Ambedkar viewed the idea of feminism in the Indian context. He, of course, in its first attempt, introduced the Hindu Code Bill, where he facilitated the legal recognition of women as being equal citizens. And he talked about the legal recognition of women through and through, both in the legislative forms and while speaking through the Constitution, through the Constitutional Assembly debates. We can see in volume 7 and volume 6 of the Constitutional Assembly debates, there has been high time deliberations and a talk of the idea of women liberation and women empowerment. And this, he in short, could be done by the right to divorce, the right to inheritance, and the right to intercaste marriage. So for Ambedkar, we see that the idea which is relevant to religion, the idea behind the religion, is not only pertaining to Hinduism by and large, and he also sees that people in India professing Christianity and Islam also have something which they ape and which they actually adhere to the idea and ideology in themselves. They also inhibit the idea of caste while following and professing their religion. So caste is not solely connected to Hinduism by and large, but we see the idea of caste sweeping in to religion of Christianity and Islam per se in India. And of course, when we talk about Ambedkar, Ambedkar is relevant to all religion and ideologies. And of course, it cannot be claimed over by any single ideology or singularity approach, because I see Ambedkar as an ideology in itself. And if, to my understanding, in the Indian context, we see the most dangerous tool of oppression in the name of caste would be marriage, for instance, which I have read in a few books, including Family Law by Flavia Agnes. So she talks about, and I'll reiterate because she'll go ahead with this, the idea of marriage has become an instrument and tool of oppression, with the carrying forward and manifestation of oppression through caste system. So you translate the idea of oppression, do a cross fertilization, and oppress through the medium and institution which is already there. For instance, marriage, for instance, family, or let's say inheritance per se in the context of India. And this is something which is very wrong, because this is the first step, or I would rather say it is the first instrument of subjugation in the Indian context, where women feel discriminated for the first point that they cannot choose their partners. And this happens to be a very strong translation of patriarchal ideologies and patriarchal manifestation in curbing the autonomy of women in India. And that is why I say that caste is something that is a bigger picture, but marriage in its essence happens to be a bigger tool for controlling women autonomy. And despite numerous rights in the constitution and well-formed institutions, we see that in India, we adhere to the idea of gender-based discrimination, both in its direct and its indirect form. And if I were to explain what type of direct and indirect discrimination would be, I would refer that we could have a read of Taruna Khaitan's idea about indirect discrimination. And in the Indian context, if we were to view the institutionalized oppression through the institutions present in the India, is one point where deliberations need to take place. But manifestation of oppression and subjugation and curbing of the autonomy of women, as basic as in the decision-making capacity from choosing partner to being laid rest to the grave, is something that we have certainly seen and are still seeing in India. Now, if I were to sum up in the most simplest manner, I would say that in the theoretical sense, the idea of deprivation the idea of deprivation, which we see that is something that is already ours. And if you deprive someone of something that is already yours, there's of course something which has to be referred to as, in the broader sense, as discrimination. And if this discrimination or this deprivation happens because of you owing to a particular sect, to a particular sex, or to particular gender or orientation, then it is referred to as a direct discrimination. And if it happens in the larger sense, that discrimination is multifaceted and happens due to the convenience of the other, then it could be termed in the larger sense as indirect discrimination. So in India, the issue is not only complex, but it is institutionalized, whereby oppression and operation of oppression in larger sense is a formalized chapter, is a formalized manner whereby you subjugate and muffle the voices of the other sex. And this is where I would like you to go back from where I started. Now look back to your answers when I asked you to answer the two questions. Do you call yourself a feminist? One. And second, how would you explain feminism in one line or in one word? The answers that you've given to yourself and a reflection would automatically speak of the mindset of the idea of feminism. And with this opening remarks and a retracing of history and theory of feminism, I would like to ask the next panelists to show more light on the particular issues of feminism. Thank you.
Thank you, Nabeela. Uh, Nabeela throwed some light on the concept of feminism, the idea of feminism, the theory of feminism. There is no single theory of feminism. As she rightly pointed out, there are different theories of feminism, and each theories of feminism may even conflict each other because experiences may vary from one nation to another, it may vary from one state to another. But one thing which she rightly pointed out is that how the social institutions help the perpetuation of patriarchy regardless of the nation, how the social institutions like that of the marriage, like that of religion, perpetuate patriarchy in regardless of the nation which the woman belonged to, regardless of the caste which she belonged to, regardless of the religion which she belonged to. But when we move to the particulars, the women belonging to different sections may have different experiences, and that might uh, that might force them to have a different understanding of feminism. With this note, I would like to move to the next panelist, Miss Flavia Agnes, senior lawyer who is practicing in Supreme Court. She will be talking to us on rape laws and Indian judicial experiences. Welcome, Miss Flavia Agnes.
Um, Actually, my internet is very bad and the sound comes on and off and the image also comes on and off. So I missed most of the introductory remarks. So if I'm totally off the track, just let me just highlight that what I should be speaking on and I can address those issues. But as described, different type of feminists in India, I come from that school, which is like experiential feminism. And much of what I've written, including my family law books, which just mentioned, the previous speaker just mentioned. I'm very grateful that she mentioned those books, and I hope those are useful. Uh, all that is written not so much from theory, but actual practice of law, and actually bridging the gap between statutory law and experiences of women who use this law. So how do we like bridge this? And that's been a major challenge for me. And whatever theorization I do is based on that experience of actually being the peg between a woman who has problems and the statute which the judiciary interprets within a court framework. And what's that framework? And what is the ideology that governs that framework? These are very important questions, and some of them have been addressed by Indian feminists, but most of them are still very hazy, and we do not have a clear idea about what exactly happens within the courtroom. We have one very interesting book here by Pratiksha Bakshi, The Secrets of Law, which is very important, where she follows a few cases, but she really analyzes them and within the perspective of the problem that the woman is going through and her court experiences and what happens during litigation in the court and outside the court, and which uh, from which a theory can be evolved, which is very Indian in its entire framework and not borrowed from the West. Because many times feminism is perceived as something that has come to us from the West. It's also perceived as aping the West. But for us, for many of us who are active in the anti-rape movement, the entire experience of feminism and entire framework that evolved is very, very Indian in its nature. They may be universal problems, but the way they are played out are within the Indian context. Also, a theory of our understanding of patriarchy may be Indian as well as Western, both, which our judges may have imbibed. And to counter that, you need to be very solidly rooted in the Indian cultural ethos, and then from there your theory must evolve. So we have several actually writers who write from these perspectives and whose theory is very valuable according to me for understanding what has happened in India. So in a way, after the women's participation in the freedom struggle and the nationalistic movement, where women did participate in large numbers, by the time we got constitution and equality, right to vote, and non-discrimination on the basis of sex, liberty and freedom, all these are very important notions. So are the notions of under Article 25 to 28, cultural freedom, freedom to religious freedom, freedom to practice the religion of one's choice, and cultural freedoms, which is there in 29 and 30 of the Constitution. So these are very important framework within which feminists function, and from there issues have been taken up. Now here, among all the issues that we have in the Indian context, maybe in some other countries also, rape has been a central pivot around which all other theories have evolved, because we've had some really gruesome rape cases, which in a way change the discourse on rape. I cannot say it is fully changed. It comes back again and again. And when we follow cases, we have to counter it all the time. Right from the apex court down to the sessions court down, trial court, we constantly have this problem. So here we have, when you take out the famous or infamous Mathura rape case, where the judges had to deal with the issue of consent. What constitutes consent or what constitutes non-consent in the context of rape? And we have here in the 70s and prior to that, all the judges having this view that rape is an attempt to frame the accused person, or when she said yes, when she said no, she meant yes, and all these kind of misnomers. But they're so deeply imbibed within our judicial system and within our society in general that it was very, very difficult to prove it. And this 1978 case of Mathura became a catalyst for the entire movement, where the judges, where this 16-year-old, the girl was between 15 and 16, and she'd been raped by policemen on duty. And the whole village was involved in that sense, which does not happen most of the time. And a complaint was registered at the same police station to which the police belonged. And yet, due to the public pressure way back in 1972, the case went to Sessions Court, Sessions Court acquitted the accused. It went to High Court. The High Court convicted the accused. So the accused went to Supreme Court. Now here you had two judgments. One is pro and one is against her. And she was a very poor, tribal, illiterate, orphan girl in a small village in the rural districts of poverty-stricken rural districts of Maharashtra. So now when this case comes up, what the judges actually look at is whether there is any evidence of resistance. And you judge resistance by injury on your body. And when the injury on your body is absent, the judges can construe that it was with consent. And this kind of extreme gender bias, which the Supreme Court judges are affected by, came as a shock to the women. It was universal in that sense, that if our judiciary, which is supposed to protect us, if the Supreme Court judges have this notion about women, then something must be really wrong with our judicial system or entire society. The power equations were so adversely balanced that they were the police, she was a tribal girl, a very young girl, and she absolutely had no mechanisms in which to resist inside a police station. And yet the judges thought it was with consent because she had not resisted, without thinking that this girl would have been just frozen when she was molested, when she was raped, and there was no way she could resist. So this, for us, became a very important theory of feminism, that what does consent construe in a rape trial? Where does consent say when you say yes, when you say no? There is no question at all here in this case of any engagement from her side, where she was called to the police station and then she was raped. So they started a whole movement in the 80s, initially a very small movement, and later civil liberty groups also joined in because it was state atrocity, it was police atrocity. And so while the judgment stood as it is, it in a way something sparked for women, ordinary women in the country, and a small number of women at that. But it made a lot of newspaper headlines, a lot of noise happened, dharnas happened, etc. And there was not any theory at that time, but what was there was that our judiciary is oblivious of the ground reality of women in India, and yet they sit there in judgment against it. So there was a demand for a new law, and the new law came in 1983, amendment to the rape law, etc. But according to me, maybe in hindsight, it did not address many crucial issues. It did change the notion of consent in custodial rape cases, where you are in government custody, etc. But it did not change the view in general. Thereafter, we've had, every time there is an incident, there is a reaction, there are dharnas, there are morchas, there is a demand for yet another stringent law, etc. And consistently this has happened. And last, of course, we know is the Nirbhaya case, where it was so gruesome. Finally, they were awarded death penalty and they are being hanged. So somewhere the focus here has been stringent punishment. But this Nirbhaya kind of case is an extreme case. It does not, it's not the normal thing that happens in a society every day. Most of the rapes are by acquaintances. In 95% of the cases, the victim knows the accused prior to the incident of rape. Stranger rapes are very, very less in that sense. So many times the theory evolved for stranger rapes cannot be applied to the rape by acquaintances. These acquaintances come in very different categories. For instance, It could be a boyfriend, somebody the girl was dating, friendly with, or it could be a teacher, it could be a doctor, it could be a state functionary, and most important, it could be a father or uncle or grandfather or brother, a male relative in her own house. And these cases do not generally come. And the entire framework that got evolved for stranger rapes is not applied here because it is your own father. It is a family member. It is a highly respected grandfather. How can he actually rape? So here we, for us, the situation is these rapes also are not gruesome. And the injuries are not visible. The rape goes on for a long period of time. Sometimes the mother is aware of it. Sometimes the mother is not aware of it. And finally, when it comes out through some accident and a case gets recorded, or through a pregnancy, for instance, then there is an entire pressure to settle the matter. Everybody involved in the justice delivery process, right from the judge to police, to family members, to community leaders, everyone in a way works together to see that this rape case doesn't go forward. And the economic pressure, the social pressure, etc., so immense that the mother is many times made to compromise and settle things, particularly if he is the breadwinner of the family. Now, these are very complex situations when a family member is involved. And in a study that we had done, because we provide support to victims of rape while she walks this legal journey, and in that process, what we realized is among the cases that come to us of the known person category, about 20% are family rapes. And these cases are not even addressed, these cases are not even highlighted. And the complexity of such a situation is not understood. So while we're still dealing with injury and consent, we're not dealing with family situations where the power and authority of the father is total. Now, here when we talk about marriage as a central functioning unit, which is very, very patriarchal, you can imagine what happens to a little child in that settings when a mother herself is abused, victim of domestic violence. And then there is this little child, 11, 12, 13, who is abused sexually. And somewhere the child feels guilty. Somewhere the child believes this is the norm, or made to understand this is the norm. There's nothing very strange about it. Sometimes she loathes herself. There are a lot of feelings that the girls go through. And the guilt is for having filed the case. And the whole family aim here is not to publicize this abuse and violation, but quietly marry the girl off to someone else. And if this incident comes out, her chances of marriage are marred. So here, according to me, there's a very clear linkage between the stigma of rape and by rape and the whole institution of marriage. And rarely have we theorized on that this institution of marriage is held in such high esteem that rape becomes the most loathsome of all crimes because it makes the girl unfit for marriage. So the marriage becomes the central focus when we look at the rape of unmarried women in the judicial discourse. So here, this is the context into which the rapist also volunteers to marry the girl, and the court also acquiesces to this that yes, you can marry the girl and your punishment will be reduced or punishment will be absorbed. Now, this is such an extreme situation where we need to look at the institution of marriage and what does actually and offered by the rapist himself mean in the broader judicial discourse of violence against women. So these are very complex issues that come up repeatedly. So one lesson that we have to we have when you deal with violence, we have two spectrums. One is the marriage as an institution, the permanency of this institution for women, and domestic violence that is situated within it, and how we are dealing with domestic violence. Second is the family abuse of children that happens, and the rape and sexual assault that happens, and how it is dealt with text, how our sexual taboos, which are culturally accepted, when they are violated, how do we view them, and and then the marriage of this girl, which becomes the central point of discussion in everything that we do. So unless we are able to keep marriage as the focus and look at these two kinds of abuses that goes on for the mother and the daughter then steps into the shoes of the mother, either at home or through her marriage, and the abuse, the cycle of abuse that goes on. So while there's a lot of literature what happens in the courts, in the police stations, at home, etc. There's a lot of literature that has come out from Indian feminist scholars. But I feel this a broader framework into which we situate marriage, into which we look at subordination of women, and in which theory challenging the patriarchal notion of a marriage are very important for our future understanding how we interpret this issue, how we are connected to this issue. I have not read much literature abroad on this whole issue of connection of abuse of children within the home, and the domestic violence that is there on the wife, and how within the marriage both these oppressions, one is at the level of domestic violence, and the other one is at the level of child sexual abuse. And the third category, which the different sexual orientation movement is now addressing, LGBTQI, etc. Each of them have very specific problems of the family. And here we need to understand how each of them have to deal with patriarchy, how a judicial discourse must evolve, taking into account all these different kinds of theories. And I said such a literature has not come much from the West, because marriage has ceased to be such an important institution over there. And lots of other kinds of relationships are accepted. But in India, marriage continues to be a central focus. So if you say dowry-related violence, domestic violence, child sexual abuse, all of them in a way, institution of patriarchy gets focused on the central focus of marriage. And that's my immediate concern, that how do we cope with these things? How do we deal with these different situations of abuse, which are analyzed differently and theories are evolved differently? But we need to connect all of them together to have a broader institutional framework or analysis of this institution of marriage. Thank you.
Thank you, Miss Flavia. Um, ma'am, Miss Flavia has rightly pointed out as to how marriage continues to be the central focus point of patriarchy, and how the institution of marriage is being used by men for deriving various advantages by affirming the subordinate status of women. Um, as ma'am has pointed out, it helps men in preserving the ornamental nature of women. Bodies of women are essential, means considered essential for procreation. They are considered very valuable means to satisfy the male heterosexual desire, and they add up to an immeasurable labor force which comes at no cost. And marriage as an institution helps to satisfy all these requirements of men. Thank you, ma'am. And now we are moving on to the next panelist, Miss Ranu Bhogal. She will be speaking to us on economics of gender inequality.
Thank you, Philip. Uh, so this is a vast topic actually. So I was kind of trying to figure out how to communicate, and I understand that most of you are students of law. However, this particular piece that I'm going to talk about is really not. Some of it will be embedded in law, but let's. So the economics of gender inequality, and the previous two speakers have already talked of patriarchy. They have talked about social norms. They have talked about how gender inequality gets perpetuated in our society, and how these social norms continue to oppress women and girls. I'd like you to, like Nabeela, I also want you to do an exercise. Maybe pick up your pen and paper and think about when you have to go on a long stay outside your city. You probably go and stay in a guest house or a hotel. And what are the services that you get in a hotel? You would be getting your, of course, the room service, the linen, and the food, and laundry services, and so those are the various services you access when you stay in a hotel. And these are services that are monetized, and therefore they are valued. So just wanted you to keep that thought in your mind. And the other uh, issue I want to talk about, we have been reading a lot about gross domestic product these days, that the GDP of the country has come down by close to 24%. It may go down further. It's still an underrepresentation. So what is this GDP, the gross domestic product? And GDP is basically the market value of the final goods and services that are produced in a country, in a society. Why am I talking about GDP? Is because I just wanted to point out to you that a substantial amount of work done by women is not captured in the GDP. And that's why it's important to understand GDP, and it's also important to understand that how women are invisibilized in the economics of even computing the gross domestic product of a country. Having said that, I want to talk about three spaces where this gender inequality in an economic sense gets practiced, gets institutionalized. One is the space of family and society. And we have heard about it from the previous two speakers also. So basically, in a patriarchal society, gender inequality is embedded in the form of marriage as a social security. So marriage, Flavia has talked about marriage as an institution. Everything is around the purity of the girl and about getting her married. And why marriage? Because that's the way to secure her life. And the roles that the society has ascribed to men and women in a conventional sense, and it starts from school textbooks and the poems we learn as children, is the father goes to earn the bread or earn the money for the family, and the mother takes care. And all our Bollywood cinema has also perpetuated, all our literature has perpetuated this whole image of a nurturing, self-sacrificing mother figure. And so a woman is seen as a caregiver. A mother is seen as somebody who's going to take care of what we call, feminists call, the social, reproductive, and productive roles. And these are primarily confined to the outside the market, and therefore does not get captured in measures like GDP. And what you don't measure, there's an adage that goes that, you value what you measure. And if you don't measure something, you don't value it. You kind of completely. So if you go and spend 5,000 rupees in a hotel stay, if that same 5,000 is imputed to the woman of the house, you are likely to even not notice it. So it's important to remember this kind of example. The other part of this economics of family and society in a patriarchal society is right to property. Although you would have heard of the recent Supreme Court judgment on the Hindu Succession Act on the ancestral property. But the reality is that that most girls will not claim their right to property. It is not considered to be, within quotes, a good thing to ask for your share. It's to ruin your relationship with your brothers. It is, you are married and you have the property of your married house, and therefore the social norm is that property is not something that a woman or a girl needs to lay a claim to. And this, in a rural society, this translates in terms into right to land. And we forget that not all women get married. So there are a lot of single women, never married women, widows, and whose rights to property is also denied by the social norms of a society. So this is one major space of, I would say, the economics of gender inequality. And denying those rights and reducing the woman into those social, reproductive, and productive roles which are not valued perpetuates this inequality and actually denies them a lot more, not just the rights to property. The second space that I want to talk about is the economics of a model which is, well, if I use capitalism, some people might say I'm a leftist. So I'm not a leftist or a rightist. But the fact is that the capitalist market production system is designed in such a way that women's labor actually ends up subsidizing that system. So this whole area of what we call unpaid work and unpaid care work is something that is fueling the capitalist market based system. Simple examples. If you live in a household where you either have a mother or a wife or even a sister, and you are going to work, going to office every day, you get your lunch ka dabba, and that lunch is prepared at home, and you of course consume that lunch at office. If you were to buy that lunch from Swiggy or Zomato, you would be paying maybe 250, 300, 400 rupees for that one meal, which factors in not just the cost of the actual stuff that you're eating, but the other costs of services and the cook who cooked the lunch and stuff like that. So again, just to remember that there is a lot of unpaid care work that women do that gets completely unrecognized. There are domestic chores, there is care of children, there is care of elderly. And the COVID crisis has actually thrown us with this thing right in our faces, because suddenly we find a lot of families have found that their children are not going to school. The husbands are working from home, and if it is both husband and wife are working, then both of them are working from home. For most middle class households with no domestic help, suddenly the entire burden of domestic work also has fallen on the women. In most households, it is women who have ended up doing the mopping, the washing of utensils, the cooking of food, the school, whatever, the lessons, the video-based lessons of the children and elder care and everything. So as a result, a lot of women have actually even been forced to drop out of the paid employment market. So this market economy also is characterized by unequal wages, and we do talk about the gender wage gap. Um, there is a complete, as I said, denial of recognizing unpaid work. We have also seen that the women health workers, particularly the ASHA workers, the Anganwadi workers, even the midday meal cooks and helpers, all of them are put in the category of volunteers. And because women have this nurturing role and they're supposed to be self-sacrificing, so they're supposed to be volunteering their services on a pittance. And you would have heard of these ASHA workers recently had gone on strike. The Anganwadi workers have often gone on strike demanding minimum wages. They don't even get minimum wages. And this is all in the frame of an market economy which is being driven by the labor of these women. And then, of course, there's discrimination in the job space. We did hear other speakers talked about various types of discriminations. I'm not even getting into that space of caste-based discrimination. Let's not touch that right now. That's another huge area of conversation. But even as women, in fact, if you remember when the maternity benefit was increased to 6 months for formal sector employees, a lot of corporates and formal sector organizations were wary of hiring women in the reproductive age group. In fact, this came out. I was talking to some HR firm people, and they said that, it's not kind of mentioned upfront like that, but definitely women who are either about to get married or who have just recently got married and likely to have kids are not preferred to be offered a job, because that's a liability to the women. Now, forget the informal sector women who don't have anything called maternity benefit. Most informal sector women, whether it's agricultural laborers or home-based workers, they're expected to come back to work within no time. Otherwise, they will not earn. They will not get the daily wages that they earn. So they have no choice. But, it just shows how things get... Um, Even an act like the Maternity Benefit Act has actually resulted, because you are looking at the parenting role is supposed to be of the woman. We of course have some organizations that give paternity leave of 15 days, but primarily it is supposed to be the job of the woman to take care of the newborn, and at least for 6 months, and then of course come back to work. And the other related area of exploration is provision of creche facilities, childcare facilities for working women, which in a lot of organizations, despite it being a requirement, is not there. If you know, the Mahatma Gandhi National Rural Employment Guarantee Act also has made provisions for creche facilities on work sites, but more often than not, the creche facility is not there, or if it is there, it's an apology. They'll put a tarpaulin and there'll be a matka of water, and they'll say, okay, you can leave your child here and go and work. So, we really don't value our women workers. Many of them do not have a choice but to work. And therefore, there is a data that we have from a research that Oxfam had done, that in rural India, men put in 32 minutes of work every day, while as against 291 minutes of unpaid work that women do. In urban India, it is 29 minutes per day for men, and it is a staggering 312 minutes, which is like 5 hours of unpaid work. And you can imagine that women who have the double burden of taking care of home as well as their jobs are actually doing an 8 or 9 hour job, plus the commute time, plus the 5 hours of unpaid work at home. So you can imagine the enormous burden that is borne by women and girls of a household. It's important to remember that, because it's also linked to this whole issue of time poverty, where women and girls, and young girls especially, suffer. And that's why we have girls dropping out of education. In rural areas, it's extremely common. Sorry. It's extremely common to find, it's expected that the girl will help the mother in childcare, in domestic chores, and if possible, then she'll go to school. But very soon, when the moment she attains puberty, because of not just the burden of housework, but also the safety issues, the girls are forced to drop out. And if only we valued the education of girls. I mean, we do have campaigns like Beti Bachao, Beti Padhao, but every truck and every auto rickshaw in this country has that slogan written behind them. But that doesn't mean that the incidence of female infanticide has come down or son preference has gone down. I mean, families may have smaller families. Now the replacement levels have come down to below 2 also in some areas. But basically, we are a country that prefers male child to a female child. We don't value our, and we want to get rid of women, girl children by just marrying them off, and that's the end of our responsibility. And we need to understand this gender inequality in that context, in the social context in which we exist. And Flavia did talk about it, and so I think it's important to remember that. And what it does is that women do not end up acquiring enough education. Even after education, you need to upskill yourself, to upgrade yourself, to be able to move up in the system to get better paid jobs, all those opportunities get denied because of this huge burden of unpaid care work on women. And what is required is a shift in social norms where it becomes a shared responsibility and not just a woman or a girl's responsibility. I also want to then talk about a third piece, which is about the how women's labor is seen. And you would have heard about the most recent labor wage code bill, the draft code wage code bill that has been presented. It had come up for comments, and Oxfam also commented on it. And it's interesting when you read the draft wage code bill, it reads as if it's written only for male workers. It's plattered with he and him throughout. There is no mention. Even the 600 skills that are listed in this wage code bill are all skills that are male skills. So, the jobs that women do are not even recognized in our wage code bill. The floral, the minimum wages that are normally there are only for the people in the so-called organized sector. And remember, it's not that women don't work. Women do work. You have domestic workers, you have BD workers, you have teachers, you have nurses, you have a whole range of women workers. And in many, many cases, I mean, you go to any private hospital, the nursing staff will not be paid what she should rightly be paid. And I'm not talking of metro cities. I'm really talking of, tier 2, tier 3 cities, smaller towns. So women's labor is always undervalued. And even our wage code bill does not really say anything upfront about addressing this issue. And which also brings me, they're really seen as volunteers or support staff or helpers, and therefore not full-time workers. And therefore, they can be given less than the minimum wage, which of course is something which is another challenge, another area of conversation. The regulation system, the regulatory bodies in our country are pretty weak and compromised. So even in organized sector, the labor force does not always get the minimum wage because it's contractualized, and there is a middleman. And so you have seen that crisis unfold during the lockdown, when hundreds and thousands of migrant workers were walking back home because they just did not get their wages. And there was no way they could have stayed back in cities because they had no money for rent, they had no money for food, and no money for traveling back. So they were walking back. So the informal sector space is something that is not addressed even in our wage code bill. I think that's something that needs attention, because 90% of women workers work in the informal sector. They work in the garment industry, they are domestic workers, they're home-based workers, BD workers. And interestingly, the sectors that have been badly hit by COVID, the travel, tourism, food services sector, the manufacturing sector, the retail trade, all the malls were shut. You know that most malls have women staff as the salespeople there. So completely hit very, very badly. And they have lost their jobs. And there's another very interesting data, which is a pre-COVID data, that in 2018, 11 million jobs were lost. Of this, 8.8 million were women. So, I think these are serious areas. So I just wanted to talk about these 3-4 areas that need attention. It is complex. There is no straightforward solution to these things. But one solution clearly is that the planners need to start giving attention to these needs. There is absolutely, they need to recognize unpaid care work. They need to create systems, and they need to ensure those systems work. So care services, elder care services, child care services, I mean, even if the provision is there, it doesn't work. So you have to regulate better. And the second thing is, of course, a lot of work that is required in the society to change the social norms, because everything cannot be expected from the sarkar. Sarkar does have progressive laws, and you are law students. So there are a lot of progressive laws. There is Prevention of Domestic Violence Act, there's Minimum Wage Act, there is, as I said, in America, there is a provision for a creche facility, there is a legally you have an Equal Remuneration Act, but of course it is not enforced. And then, the regulatory bodies need to do their job well. And as a society, I think each one of us has the responsibility to start making the changes. And I think all feminists will say that personal is political. So the change has to begin with self, and start examining right from the role you play in the house or home where you live, with whoever you live, how you treat your domestic help. Did you pay your domestic help during the COVID lockdown of 5 months? There are a lot of stories of domestic help not getting their salaries. So I think these are questions. These are, I think, ethical questions. These are social norm questions, and then of course law, and then of course implementation and of the law and the regulatory bodies. So that's all I'd like to say. And one last point, you would have also heard about ease of doing business. And in fact, today's newspaper carries this news that Uttar Pradesh has shot up to, I think, the second place in ease of doing business. And let's not forget that the labor laws have been diluted to go up the ranks. And what does that mean? It means more than 12 hours of work, continuous 7 days of work with no break, and many other relaxations that have been given in the labor laws to attract business to the state. And I think this also needs to be looked into seriously, because what it does is that it again pushes women out of paid labor force. So with that, I will stop and happy to engage more later. Thank you very much.
Thank you, Ms. Ranu Bhogal. Ms. Ranu Bhogal have brought in number of serious issues before us, and she has rightly questioned. She have rightly raised a question as to the need to question ourselves, to as a need to question each and everyone who is hearing this session. We all contribute to this exploitation directly or indirectly, knowingly or unknowingly. We all contribute to this exploitation that is happening around us, the economic inequality that is happening within family, how the immeasurable labor force that the women are contributing to the society is not valued, is something that uh, we should recognize and we should act upon. After all, the legislature, the judiciary are all just the reflections of us. So we can't simply question, we can't simply blame the legislature and judiciary all the time. We should be able to question ourselves, and we should be able to bring in small changes which will bring in an ultimate change in our society. So now moving on to Professor Jhuma Sen. She is one of the conveners of the Indian Feminist Judgment Project, and she will be talking to us on the feminist judgments in India, challenges and prospects.
Thank you, Arjun. I hope I'm audible. It's always a challenge to be the last speaker on a panel on a Sunday, especially what seems like a post lunch session. But I'll try, and I feel I get a general feeling that that my speech is going to be a happy speech. Because I will be talking about possibilities, radical possibilities, in a bit. My mandate that was given to me was to speak about the challenges and prospect of the Feminist Judgments Project in India. What I will do is I would actually like to first briefly introduce the idea of feminist judging or feminist judgment writing or feminist judgments project for that matter, before I speak about challenges and the future, or the feminist future that it probably holds for a project like that in India. Some of you may of course know about this project, and for those of you who do not know what it is, this is usually my elevator speech, that the Feminist Judgments Project is about writing alternate judgments to judgments that could have been written better or written differently by using a feminist lens. In other words, it is a shadow judgment project, and there have been many shadow judgment projects, across the world. And there have been several feminist judgment projects around the world as well, starting with the Women's Court of Canada in 2006 or 2008, I'm forgetting the year, when a group of Canadian feminist scholars, activists and lawyers, they all came together to rewrite the Canadian Supreme Court decisions on Section 15, which was the equality clause in the Canadian Charter of Rights and Freedom. Now, the goal of these parallel judgments was to see what equality, as defined under Section 15 of the Charter, which was enacted into law later in 1982, could look like, if the court took priority of what equality should mean, in these decisions. And since the Canadian experiment, a number of jurisdiction-specific feminist judgment projects have bloomed across the world, in England and Wales, then Ireland and Northern Ireland, in USA. There are multiple projects in USA, in Australia, in New Zealand, in Scotland. There's been an international feminist judgments project, international law feminist judgments project as well. And of course, in India. A week or so ago, in fact, I was contacted by the conveners of a proposed Pakistani feminist judgment project. So we are now not the only South Asian projects, as we used to claim earlier, that we are the only South Asian project, so far. There is also a Pan-African feminist judgments project, which has been started. Now, in all these projects, reasoning and in some cases, the outcome of key decisions, key judgments have been reimagined through a feminist lens. Now, I don't want to get into a discussion of what a feminist lens is, what feminist legal method is. That will take us to a whole different territory. But I think from the discussion that we have had today, we at least have a sense of what a feminist lens looks like. Now, this act of rewriting or reimagining a judgment, it takes into account, usually in all these projects, it takes into account intersecting inequalities of class, caste, race, disability, sexual orientation, gender identity, ethnicity, national identity, language, you name something, a form of inequality, and it is usually part of that that reimagining, endeavor. The project so far, the project, globally, because it's not, this is not like 2008 when there were like only three projects actually only in existence. There have been multiple projects now, and the project has actually served as I would say as a critical pedagogical tool by bridging the distance between feminist theory and feminist practice, and how it has sought to do that by radically reimagining the role of the judge to adjudicate differently by remaining faithful to the same constitutional and legal rules that bind her. Now, there's a lot written on in feminist scholarship, feminist legal scholarship, and feminist scholarship has indicated how legal rules as well as their applications by the courts continue to remain, sites of embedded patriarchy. You have this image, this figure of the reasonable man, who is the standard against whom reasonable expectations are evaluated. Flavia is on the panel, and she has written extensively on this. You have Usha Ramanathan. There's so many scholars in India as well as globally. They have written about it. Now, the pedagogical potential of the Feminist Judgments Project, it lies in the fact that all these alternate judgments or missing judgments or dissenting opinions, call it whatever, these reveal the extent to which cases could and should have been decided while remaining faithful to the legal and constitutional limitations. So you are deciding a case by remaining maintaining fidelity to legal rules, to a particular statute, to a particular form of interpretation, so on and so forth. So the heart of this project is actually an attempt to engage in very real world judgment writing exercise and move away from this the detached, somewhat detached exercising feminist academic critique of judicial decisions. Because feminists, not just feminists, we all always we criticize, we critique, we make academic critiques of judgments, and to be very honest, there is no dearth of bad judgments, or even apparently good judgments, which can also have a critique. I'll come to that in a bit. So there are no dearth of bad judgments in India. It's there's actually, so you can actually have like 20 different feminist judgments project in India. Anyway, so but to talk about how the or what the impact of this feminist judgment projects has been is, it's actually, I will call it a sort of a collective achievement of these feminist judgment projects globally, and it has truly been awe-inspiring. It is, someone, I can't remember who, I think it was probably Rosemary Hunter, said that this is a form of academic activism, because now you see this kind of project sort of blooming. It's literally like it's spawned across the world, and they have one of the main sort of takeaways, or one of the major impacts has been that they have radically reimagined pedagogical thoughts. They have also been used in judicial trainings in some jurisdictions, and have fundamentally, I think this is the most important bit, they have fundamentally questioned the idea that making and applying the law is a neutral, objective pursuit, and demonstrated in its place how cases could have been reasoned or decided differently, even given the law as it stood at the time of that decision. Recently, I think this was last year, in one case, the Canadian Supreme Court has actually looked at a rewritten feminist judgment favorably as a legitimate adjudicatory practice. So there are the potential of this kind of project is actually, it's my sincere belief that it's actually quite far-reaching. Now, it is often asked by many that can one be a judge, and feminist at the same time, because judges are supposed to be neutral. There is this sort of this myth of this objective judge, myth of this neutrality of of a judge or of an adjudicator, or adjudicatory practice, or law. So can one be, so if you're a judge, you should not take sides, you should not have ideologies. And feminist ideology is definitely, being a feminist is actually an identity. It is an ideological position as well. But so this question actually, obviously this question comes forth, that can one be a judge if and a feminist at the same time. It is because there is this assumed neutrality of a judge and this assumed objectivity of law and the adjudicatory process. But I think it is really safe to say that these are as far as truth from truth as possible. And why is this so? Because judges often have to decide cases in which the existing rules provide no clear answer. In such cases, what do? So they often have to turn to their own values. They have to sort of, own values, own notions of what is right, what is wrong, what should be done as opposed to, what should not be done. In other words, the judge is actually actively deciding, is making a decision. So judges sometimes have no choice but to fall back on their values and perspectives. Why shouldn't feminist values and perspectives be included? And then here there is this whole other discussion of the voice, because when we look at a judgment, if you take out any judgment, even the once celebrated Air India versus Nargesh Mirza, if you read those judgments, you will see that the voice of the judge, this judicial voice, is decidedly male, so which means that what we associate as norms, associate as values, associate as, practices, as sort of like legitimate adjudicatory practices, these are, in many ways, these are, this is a male judge speaking. This voice is that of a male judge, and in a space like India, it's an upper caste male judge. So the long answer to this question, can a judge be a feminist, is actually yes. One can be a judge as well as a feminist, and being a feminist judge does not mean referring to feminist theories and texts, but bringing in feminist consciousness in judicial decision making. And this methodology of feminist judging is likely to demonstrate the ways in which a judge or judges make choices about interpreting and applying the law. And the feminist approach will then scrutinize and evaluate the body of, how a body of legal knowledge is constructed, or how it is excluded, or who it excludes, and the sort of the gendered implication of these. Now, similarly, by privileging of certain reasoning processes over others, these will be questioned. The privileging of these, certain adjudicatory practices, certain reasoning processes over others will be questioned by a feminist judge. And you see this, I think, this starkly comes out, in rape law trials. The things, from Mathura to to beyond, you see that there are certain kinds of womanly or a certain kind of behavior which are sort of seen, which are looked at favorably by a presiding judge. So a feminist judge will also be careful about facially neutral laws and rethink these reasonable man standards, and it would be possible to achieve these feminist goals within the constraints of the existing legal rules and practice. So one cannot say that, oh, you are bringing in something from outside. This is not what law looks like. And a feminist method of decision making would then, in the words of Rosemary Hunter, who's like one of these prime architects of the feminist judgments project across the world, will entail the judge asking the woman question and notice gender implications of apparently gender neutral rules, as well as implications for other traditionally excluded groups, contextualize and particularize, reasoning them, from context, and making individualized rather than categorical or abstract decisions. For example, from saying that, oh, women misuse laws, a feminist judge will obviously will try to understand that, what misuse means, and why is it so that only in the context of certain laws like 498A, this backlash is sort of targeted at women litigants. So why is it so? So a feminist judge will also, for example, promote substantive equality over the formal understanding of equality. And I think since we're talking about equality, I think you also forget that that a constitution is a feminist document. It goes beyond the technical reading of formal equality and actually inscribes the promise of substantive equality in its text. It imagines the creation of an egalitarian society. Unfortunately, Indian courts have historically interpreted equality in a highly formalistic manner. Something which has been corrected, later, in Navteej Johar, for example, in Justice Chandrachud, in Navteej Johar, actually, you will note he actually talks about the substantive content of Article 14 and goes on to chart a language for indirect discrimination. The effect of law, there the court states, must be understood by taking into account the broader social context within which law is embedded. So, in other words, it must therefore take into account the broader social context within which law is embedded. It must take into account the intersectional nature of sex discrimination, which cannot be said to operate in isolation of other identities, especially from the socio-political and economic context. So this is part of reasoning, Justice D.Y. Chandrachud's reasoning in Navteej Johar. Now, to give an example of how indirect discrimination sort of operates is, if you think of Rajbala versus the state of Haryana. So it was hailed as a great judgment. It was seen as an empowering judgment by many. But if you actually scrutinize, try to have a feminist scrutiny of Rajbala versus state, it will not withstand a feminist scrutiny. So what does the court do here? So for instance, in this case, the Supreme Court, this is 2015 judgment, made educational. So there were the state acts amending the Panchayati Act. So these were amended, and this was subsequently challenged before the court. And the Supreme Court made, basically made educational qualification mandatory. The Supreme Court upheld the act and they made educational qualification mandatory for contesting panchayat election. And in his argument, the court said that it is only education that gives a human being the power to distinguish between right and wrong, good and bad. But if you think about it, sort of, if you look at it critically, so on the face of it, the decision may appear to be gender neutral, because it is not saying that, oh, this is this is that this qualification was only meant for women. So it appears to be gender neutral, but it actually impacted women adversely, in a huge manner, because as only I think 20 lakh, or it was less than 50% of this 46 lakh or 45 or 46 lakh women in Haryana above 20 years who were matriculated and only qualified to contest. So effectively it disenfranchised a large number of population. And who were these people, and why is this an exclusionary judgment? This is an exclusionary judgment because it impacted women, especially Dalit women and minorities, the most. Now, so this is this is the sort of the structure. This is the this large imposing structure with embedded patriarchy within which the feminist judgments project in India, the IFJP, it kind of germinates. So it is a loose collaborative of around 75, maybe a little more, because we have added some cases, 75, 80 feminist scholars, practitioners, and activists drawn from legal and other disciplines who are rewriting or writing, writing as an RIGHTING. This is what feminist judgment practitioners how they put it. So who are rewriting or writing some select judgments on a range of issues, and these issues range from substantive equality, sexual autonomy and consent, employment discrimination, religious freedom, legal pluralism, indigeneity, disability, caste. These are just to name a few. There are multiple other sort of axis of marginalization as well. And currently it's there are three coordinators. So there's me, there's Dr. Aparna Chandra, there is Dr. Rashna Chaudhary. So we were kind of sort of coordinating this entire process of sort of anchoring the project. Now, when we started thinking about the project, we wanted to see, for example, that what are the ways in which the Supreme Court of India, and not the Supreme Court, we're actually rewriting some High Court decisions as well, and also some tribunal decisions, lower court decisions. So we are looking at how the judiciary could have reason, for example, say in the Mathura case, the Tukaram versus State of Maharashtra, which was largely about, Flavia has mentioned it, it was largely about prosecutrix credibility in rape trial, or Geeta Hariharan versus RBI, which was about guardianship rights of a Hindu mother during the lifetime of the father, to advance the jurisprudence of gender justice. We tried to ask the question that could one then imagine how a rewritten judgment in, say, State of Bombay versus Narsoppa Mali, which held that personal law was immune from constitutional scrutiny, how would it look like if women were central to its reasoning? In fact, could we even reimagine and rewrite judgments that upheld women's interests? The so-called good judgments. Like, for example, Vishakha versus State of Rajasthan, which laid down guidelines of addressing sexual harassment at workplace, or Shaira Bano versus Union of India, which invalidated instantaneous triple talaq. Or what would these judgments, or what would those judgments that interpret facially neutral provisions, how would they look like when rewritten from a feminist position? What are the feminist critiques that would inform and accompany such judgment writing process? So these are just a few ideas that that guided us to sort of probe the radical possibilities of this project. And when we issued a call for proposals, we had made a conscious decision to not specify what cases would we would consider as landmark cases, because in our feminist practice we wanted to dismantle what is considered as as canon or as a landmark case, because what is a canon in any in canon anyway. And in addition to this, we also made a choice to not restrict our participants to the legal discipline alone, but actually we encourage sociologists, historians, political scientists, who work with law to be a part of this project, with an understanding that law is a product of history, politics, and culture, and not the domain of lawyers alone. Law is too important to be left only to lawyers. And these flexibilities in the initial part of the project, while making it diverse, also threw up some challenges. The first challenge was, receiving a disproportionate number of proposals in the traditionally what we understand as the gendered areas of law. For example, matrimonial law, criminal law, but nearly nothing in those facially neutral laws like company law, tax law, contract, tort, and so on and so forth. And even though we reached out to our peers in the academy and the legal profession later with request to identify and write judgments from unrepresented areas, like a feminist rewriting of cases involving the intersection issues of indigeneity, land rights, and legal pluralism, or a feminist critique of state, in a host of judgments, including cases involving even anti-terror laws and extrajudicial killings. We acknowledged that it was really impossible to have a fully representative body of judgments given several constraints. The second challenge was, making a space in the workshop where disciplines could really sort of speak to each other, in the judgments and the commentary, because in all the cases, the sort of this feminist judgment writing practice usually has a commentary followed by a judgment. So the commentary situates or locates the particular judgment in its, the original judgment in its, social, political, historical context, even legal context. Does a critique of the original judgment, demonstrates how the rewritten judgment sort of makes a departure from the original judgment, so on and so forth. So we did make that space in the workshop, so that different disciplines could speak to each other through the judgment and the commentary. In most cases, this technical challenge was overcome by disciplines actually informing each other. So someone who was writing who was not trained in law would bring in literature and her own disciplinary practice in the in the text of the commentary or the judgment, and someone who is trained in law would help the the other who's not trained in law to bring in that sort of legal lens. So I think this is actually a part of this collab, because the nature of this project is also very collaborative, and this is that collaborative aspect of rewriting this judgment, and sort of an aspirational part about writing together. That's what we called our project. We are writing as an RIGHTING together, that we actually tried to articulate. Now we had two workshops, one in May 2018, and the other one was followed in October 2018, and the year after that, which was last year, was mostly sort of chasing our contributors to for the drafts. We designed these the first workshop as a sort of a methodology workshop. We designed the second workshop as a as a writing workshop, and we also invited, in the spirit of the other project, discussants or critical commentators or critical friends to provide real world checks and balances on these judgments. We rewrote is now a little more than 40 odd judgments, and their commentaries to be shared between 3 publications. We have one of those publications, the special issue with Indian Law Review, which is going to be out very soon. It's in the process, and we are working on the second one right now. Now, one of the significant practical challenges that emerged in the India context, is in the India project, was the lack of information or facts on crucial issues, in the appellate judgments, which led participants to look for the lower court judgments, which are always not easily available. And this threw open up a conversation on feminist archiving as a mode of advancing feminist judicial practice. So, for example, we were rewriting the Mathura judgment. Tukaram was the state of Maharashtra, which acted as a watershed moment in the history of Indian women's movement. But we struggled for several months, actually almost a year, to retrieve the High Court record, without which there were significant barriers to the rewriting process. We finally managed to procure the High Court record only a few months ago. During the workshop, we also tried to understand the relationship between feminist lawyering and feminist judging, and we brought in some women judges, including some who identified themselves as feminist judge, and they said that we could not, there is a practical difficulty of writing a feminist judgment in a real court, is that we do not have feminist lawyers, feminist we do not have feminist arguments made always. I mean, there are obviously exceptions, some notable exceptions, but we do not always have feminist arguments made before us. So we tried to understand this relationship between feminist lawyering and feminist judging. Should a feminist judge include feminist pleading, which have not been used by the affected parties? And if yes, then how should legal rules be then subverted or manipulated to evolve a feminist judicial practice, while remaining alert to the fact that judicial power is also a form of public power and it should be used responsibly. In order to respond to these challenges, we have in some cases used the acknowledged judicial practice of the court appointing an amicus to help in the production of judicial common knowledge. So we have done that, and in our workshop we also faced this was this is, I think, it's a common, not just our workshop but like across all the project, the common law sort of position or privileging of precedent. Because it was particularly sometimes, not at all points of time, but sometimes it is very unwieldy to sort of subvert. So how does one respond to a bad precedent or an unfeminist precedent, for example? I personally think that although the nature of the project, at least so far, is decidedly academic, like I said, some have already called it, pointed it out that it's a form of academic activism. The reach of the project is actually far wider. For one thing, feminist judgment writing methodology, if you if you think of like classroom practices, so if feminist judgment writing methodology is used in the classroom either as a separate course or as part of sort of building it into a regular course as we understand it, then I think they have a tremendous potential to impact students who are planning to become, who will litigate or who are planning to become judges. So as far as that is concerned, I actually see a lot of potential for this kind of project, also in judicial training, and this has actually happened in some in some countries, in some jurisdictions where judges have actually embraced this project. So they have used the product, which is a sort of the manual and the book, for judicial training purposes. Now, just to conclude, I think I'm probably running over time or almost there. Just to sort of conclude my my thoughts about sort of my evaluation of a project of this nature is that it is not only the contribution of the project, if you look at it individually or if you look at it like the sort of the global scope of this project, that matters, but also what Margaret Davis said, that it is it builds a collective force as a sustained critical mass practices that bring in new meanings, new directions to legal culture. So you're essentially trying to change norms, you're trying to change dominant patriarchal norms, and in that respect, I think the feminist judgment projects, they offer an opportunity for a really wide scale collective activism as well as critique across different legal cultures, across different legal jurisdictions, and in that ways it could in some way contribute towards some cultural change. And of course, I mean, I don't think this this needs to be mentioned, but it is always, a project like this is always, it is an important tool, but it's only one of many tools, many sort of tools which are ever evolving to resist these oppressive legal norms and processes, and to sort of craft a collaborative or creative space by either occupying the master's house or dismantling the master's house, whichever way you want to sort of look at it. I think I will stop there. According to my time, I've gone beyond my time.
Thank you, Professor Jhuma. Professor Jhuma has brought into our attention a new project called Feminist Judgment Projects, which might be unknown to most of the viewers who are watching this panel discussion at this point of time. So this is a new area where even academicians are not need not stay back. Even academicians can actively involve in the feminist movements that is happening around the world. The lawyers have a lot to contribute. And as Professor Jhuma mentioned, law is not a single island. Law is linked with other subjects like that of history, politics, literature. So it is, and there should be an interdisciplinary approach while addressing the various issues that are being posed before us. While we are trying to address, while we are trying to suggest solutions, we should have an interdisciplinary approach. And as she also mentioned, that constitutional means the ideal of right to equality, where man is being set as a standard to which women should always look up to and strive for, will no way help our system to serve justice to the victims of means various forms of violence, the women who are facing problems around us. So now we all our four panelists have presented their presented on the diverse topics. Now we will move on to the questions which are being posted. There were about 800 participants who have registered with us, and we have large number of questions which have been posted in the YouTube platform. We will entertain two questions. Moving on to the first question. Uh, the question is directed to Professor Jhuma Sen. The question was raised by Pankaj Mehta. The question is that, do you feel the portrayal of feminism as a form of protest rather than of moral self-reflection has diverted attention from issues like intersectionality and feminist interpretations of justice? Question is directed to Professor Jhuma.
Are we taking a bunch of questions and then responding?
No, we will answer this question and we can move on to the
So,
next question.
can you just repeat the question again? It was a long one.
Yes. Do you feel the portrayal of feminism as a form of protest rather than of moral self-reflection has diverted attention from issues like intersectionality and post-humanist interpretations of justice?
Okay, I'm not sure I understand the question very well, but this is what I understand. So the form of portrayal of feminism as a what was it? What was the word? As a
form of
protest, right? Yeah. So as a form of protest. So I know my first, of course, my sort of question to that is like, who's doing that portrayal? Are feminists? Is it a sort of self-portrayal, or is someone else portraying that? Is the judiciary portraying that? Is the society portraying that? But I would but feminists have feminist practices have been seen as disruptions, and disruptions are good things. Disruptions to the status quo. So if that portrayal is happening, I'm happy with that portrayal. I'm not sure I get the question about intersectionality, because intersectionality is very much, and it ought to be very much part of feminist practice as well as theory. Feminism is something which is not separate or distinct from intersectionality or an intersectional practice. A good feminist practice would mean it is an intersectional practice. I don't know whether I was able to respond to that to that question very well, but this is what I got, and this was my response to what I understood.
I think we've
I,
lost track of the
I lost
moderator.
my connection in between. Do any other panelists want to add anything on this question?
Okay.
Anything more on this question? Can we move on to the next question?
Yes, please move on to the next question, because it was not very well put up, so I couldn't understand the essence
The
behind the
second
question. Yes, go
question
ahead.
was posted by Ipshita Ganshala. And the question is that the portrayal of feminism as a protest rather than a journey of moral self-reflection has diverted attention from issues like intersectionality. Your comments, please, from
Same question.
Ms. Ranu Bhogal.
It's the same
No, it's a
question.
different
It's the
question.
same question.
It's a different question.
Can you project the question by any chance? If we can read it, it might be useful for us, easier to, because these are
On the
long
screen.
questions.
Sailesh, can you please project?
Yeah.
And
Sounded
it's
like
almost the
similar to
same
the first
question, but
question.
asked by
It
a
sounded
different
exactly
person.
the same to the first question.
Yes.
Yeah.
We will
Or maybe
take-
you could pick up a slightly more different question.
Yes.
Different question,
Okay.
because that's already been answered.
Yeah.
Somehow.
Moving on to the next question. Justice Chandrachud has once remarked the Constitution of India as a feminist document, despite the lack of participation of females in its drafting. Do you feel in practice the Constitution of India has shades of feminism? This question is not directed to any panelist as such. Any of you, if you are interested, you can respond.
Maybe Flavia.
Yeah, I know that Chandrachud has said this, that the Constitution of India is a feminist document. You can see certain very progressive thoughts in the Constitution, like, for instance, equality, Article 15, non-discrimination, Article 15, and Article 21. These are very progressive thoughts for its time when it was enacted. But their interpretation in the courts have not necessarily been very feminist. And in a way, we are susceptible to subverting women's rights at the time. So we need to understand, we need to have judgments which will expand this particular concept. For instance, equality. For instance, non-discrimination. And only with the thought of the judges expanding this will it actually be a feminist document. For instance, what Vishaka judgment tried to do, sexual harassment at workplace, and it took certain challenges that women would go through if they have to go to the criminal legal system and evolve an alternate system to address these particular issues. So that required a certain understanding of women, but it did not stop there. It has to move forward in order to give the equality concept sort of a framework. We had to then have a law which came in 2013 and also certain judgments which expanded the scope. So it's a long journey. While Constitution has seeds of our feminist document, cannot end there, and unless if the interpretations are contrary to the Constitution aspirations of empowering women.
Okay, ma'am. Do any of you want to add anything more to this question about the
Okay, I just
Constitution? Yeah.
Yeah,
Yes.
I actually, I mentioned this, when I spoke that the Constitution of India is decidedly feminist, because if you look at 15, and if you look at the promise of substantive equality, that is, that is, that is a feminist. I mean, it can't be like, you can't be more feminist than that. It's substantive equality is inscribed in the in the heart of the constitution. And I think in Navteej Johar, this was very well sort of articulated by Justice Chandrachu's opinion. If you look at it, if you read the judgment closely, you will see that this, why the constitution, I mean, so what is actually the heart of the, of equality, because he talks about the substantive content of Article 14, and the substantive content of Article 14 is actually quite broad. It is something that takes into account, that should take into account indirect discrimination as well, for example. The constitution, at its core, is a feminist feminist document. Now the way the way equality has been understood by the courts, so if you think of constitutionalism in practice, and if you think of the judiciary as an institution that practices constitutionalism, and when I say judiciary, it's not just the Supreme Court, it sort of cuts across. The courts have not really sort of lived up to that, the promise of substantive equality in the constitution. And I'm not even going to get into criminal criminal adjudication, criminal law adjudication, because that is another completely different sort of hellhole altogether. Yes, so I think I'll stop there.
Thank you, Professor Jhuma. We
I'll
have,
just add one line to
yes,
what
yes.
I'll just add one line to what Professor said. I think it's the legal process that is flawed, not the document. The document or the superstructure is already there, and the superstructure is strong enough to hold in its ambit everything and anything that is accommodative of inclusivity. So the idea of constitution has always been inclusive. The parent document or the document which derives its source. It's the legal process that has a problem, or the system or the structure in which we are in has some issues that has been there, and the problems mainly are because of interpretations. Just to add a point to
Thank you,
what
Ms.
Professor
Nabeela.
said. Yes,
Now,
I also
yes,
feel the Constitution given us the framework in which a judge like Justice Chandrachud can give a judgment like the Nafti judgment. But there are so many judgments. In fact, on the 77 itself, the earlier Supreme Court judgment on this, whereas Justice A.P. Shah gave a as the Chief Justice of Delhi High Court gave a very different interpretation, and the thing was overruled at the Supreme Court level. So again, there have to be a struggle. So you can imagine how uh, different stands are there, and unless the judge himself is able to read this read constitution as a feminist document, it will not have life actually in the court. So it can be very, very regressive as well. Using the same constitution, everybody interprets it in their own way. So it's very important that sensitizing the judges and making a feminist is very, very important.
Thank you, Ms. Flavia. We have a lot of other questions, but since we have exceeded our time, we will be concluding the session soon. I will just make just one remark that on this last question, which we have discussed, that the protection of interest of minority, though it has been advocated by the Constitution, and though it is the role that the court is expected to play in our society, at times, as Professor Jhuma rightly pointed out, where man is always set as a standard, and women are always forced to look upon that standard, and judges write judgments in that way. So it is very important for the Constitution to be a feminist document, as well as the Constitution should reflect the feminist ideas, the feminist philosophies, as well as the judges should also be a feminist, means reflect the feminist values, the feminist ideals. With that, I would like to thank all the panelists. This was a very fruitful discussion, and our viewers are enjoying it a lot. There are a lot of comments which are coming up. So thank you all for your valuable time, and especially for spending your time between 1 o'clock to 3 o'clock a Sunday for this session. I would also like to thank Symbiosis Law School and OXFAM India for partnering with us. Thank you.
Thank you. Yeah. Bye.
Thank you.
Bye,
Thank you
everybody.
so much.
Yeah.
Bye bye.